Good evening, everybody, and welcome to our back to school session of the Interventions in Disability Politics seminar series, hosted by the Centre for Applied Philosophy, Politics and Ethics at the University of Brighton. It's wonderful to see you all this evening, and I hope that you've all had excellent summers. We are very lucky this evening to be joined by Maral Nosratzadeh from the University of Leeds. Maral is a doctoral candidate in law at Leeds and the receiver of the Doctoral Studies Prize in law. She works extensively, among other things, on access to advocacy in multiple European countries, on the right to independent living, how that is interpreted and operationalized transnationally, and as we'll hear today, on women's rights, selective abortion, and eugenics. Maral will speak today for, I believe, around 45 minutes, after which we will have a comfort break and then return for Q&A. So with no further ado, Maral, thank you so much for your time and take it away.
Thank you for your introduction. Hi, everyone. It's a pleasure to be here, and I would like to thank Luke and his colleague for this opportunity. Today's talk is specifically focusing on disability-selective abortion under the UK law, but I will also make an international comparison, particularly under the CRPD. But I just wanted to mention that I appreciate this is a sensitive topic, and if there's anything in this content of the talk that you find triggering, please feel free to flag it up to me. And also, there would be some terms that are particularly kind of legal terms that might be unfamiliar to some people. So if there's any questions about any of those terms, please give me a shout. Feel free to kind of bring it to my attention. So just to kind of give a structure of what are the main objectives for this presentation, I'm going to sort of introduce and reflect on the disability selective abortion under the UK law and discuss some of the eugenic ideologies that are underpinned and influence the UK law. And then I will provide a summary of the UK legal framework against the international standards adopted by the UN, particularly the CRPD, on the idea of abortion and disability, which stems from the research that I did in my LLM. And then I'm going to talk about, very briefly, talking about the Northern Ireland's fairly new framework on disability selective abortion, and then exploring some ways of how we can reform the UK law, the current UK abortion law, to make it hopefully less disability sort of discriminatory. Under the current UK abortion law, which is from the Abortion Act 1967, there are a number of grounds that makes abortion lawful, and one of those grounds are disability selective abortion under Section 11D of the Abortion Act. And under this ground, there's a criteria which states that if there's a substantial risk of the child being born to be suffering from a physical or mental abnormalities, which could be severe, which have an effect to make them severely handicapped. Oh, the slide just moved, sorry. To make them severely handicapped, then it is lawful for a woman to request abortion. But as you can see from the terms severely handicapped and substantial risk of abnormalities are underpinned by a medicalized approach to disability, whereby disability is viewed as an individual medical condition that has the effect of affecting quality of life of disabled people. So it's viewed as an illness and which can cause a poor quality of life, rather than seeing disability as something that stems from the society and the environmental impact of how we view disability. So it is a very medicalized approach and an outdated understanding of how we view disability, which has affected the way it's been practiced up to this day. So the UK abortion law, it stemmed from this eugenic ideology and philosophy, which seeks to filter the society from those who we call as inferior, i.e. people with disabilities and impairments. And there's an encouragement to promote the birth of fetuses who are superior, i.e. abled, so born with able bodies. So there's an ableism element. I don't know why the slides keep moving. Ableism element underpinned by the Abortion Act. And is underpinned by this idea of seeing disabled fetuses as inferior to the society, which then stems from these social and cultural stereotypes of how we view disability. And this can contribute or to a great extent influence women's reproductive choices, the way society has viewed disability, and giving birth to a child with an impairment has influenced women's choices in terms of making decisions to abort fetuses with impairment. And there has been a long-term conflict between feminists and people from disability studies, this tension of between pro-choice and pro-abortion, which kind of emphasize on women's bodily autonomy and integrity, and the movement with disability studies, which talks about how disability-selective abortion is discriminatory. But Saxton from 2010, it's talking and challenging that pro-choice idea of abortion, and kind of talks about this eugenic ideology and pressure of medical professionals on the women to terminate their fetuses with disabilities has stemmed from the narrow view of how we see disability in a society, and we see it as ultimate suffering, which stems from the social factors rather than being the real choices of women to terminate. So women are constantly under pressure by medical professionals to abort fetuses with disabilities. And this is how it's been viewed. It's influenced by how disability is being viewed by the society as something negative, as something causing suffering, and that a lot of women feel that they're not going to be supported raising if they give a birth to a disabled child, and how are they going to, for example, provide care or raise a child with a disability. So there's a social pressure and a medical pressure on women that influences their choices. So their choices are not necessarily always coming from the idea of bodily autonomy or individualistic choices, but is influenced by these social pressures of how we narrowly view disability as something negative. I will read a quote from Saxon, which says, choice doesn't exist as a national opinion, but choice is sort of stems from this oppressive values and attitude about disability, in the choice has been a sort of long-term argument upon justification for terminating fetuses with disabilities, but it is sort of simplistic to view women's choices only influencing from their bodily autonomy and their individualized choices without thinking about the fact that many women who get pregnant with disabled fetus have this fear of not being supported or of their children being viewed as a negative member of society who cannot contribute to the society or who cannot be an active member of society, which then influence their choices to go through selective abortion. And there are other problems which again links to this eugenic ideology underpinned by the 1967 Act. At the moment, there's no legal definition of what it means by substantial risk or serious or severely handicapped. So the legislation is using a very broad medicalized term of severely handicapped without any scale of severity of disability to justify termination of fetuses with disabilities. So this broad interpretation is quite subjective and allows for a wide scope of termination and of the type of impairment that the fetus can also have, which is one very big legal problem, at least from a legal interpretation perspective, to justify disability-selective abortion. Another very big problem with the UK abortion law currently is that for a termination of a non-disabled fetus, there is a cutoff point, a legal cutoff point at 24 weeks gestation, whereas this there's no time restriction if a fetus is diagnosed as a disabled fetus. So if there's a criteria to, if the fetus has met that criteria of being severely disabled or severely handicapped, then there's no time restriction on facilitating abortion, which means that a disabled fetus can be aborted up to birth, up to due date. So there's a differential time gestation in the UK law for the termination of disabled and non-disabled fetuses. And I argue that this differential time gestation leads to a discriminatory practice against not just disabled fetuses, but disabled people in the society. And it displays a negative image of how we view existing disabled people within the society, because it's sort of sending a message of eradicating and saying that disabled people are not valued in the society, and if there's any impairment on the very wide scale, they should be aborted and not be born. So it's questioning the value of life of people with disabilities, which then leads to greater social and cultural and political inequalities. And also this differential time gestation between disabled and non-disabled fetuses for termination violates the principle of equality and non-discrimination according to the UN standard, particularly under the CRPD. So it's not only violating the equality rights under the UK law, but also under the UN standards, which UK is part of the CRPD and has ratified the CRPD, but they are violating the CRPD obligations by having very ableistic and eugenistic legal practice for termination of fetuses with disabilities. And there has been an ongoing so recommendation by MPs and professionals and lawyers about making at least some reforms to the current UK abortion law. One of those recommendations have been applying a same time gestation, so sort of have a cap at 24 weeks for termination of fetuses regardless of disability, and that has been rejected on various accounts by the UK Parliament. In 2017, also, the CRPD committee has emphasized that the current UK abortion law is contrary to Article 5 of the CRPD, which is the principle of equality and non-discrimination. And therefore, they have been sort of express element of violating international standards. Therefore, the committee has recommended the UK government to amend and reform its current abortion law, which has not happened to this day. And as part of my research, I conducted primary analysis and systematic analysis of UN CRPD concluding observations. For those who are not familiar with the concluding observations, those are reports that each member of UN CRPD committee will submit to the committee, which kind of detailed various different issues under different articles of the CRPD. And in 2017, UK had one report, which you saw on the previous slide, and it was brought to the attention of the committee that UK is violating Article 5 of the CRPD, which is about equality and non-discrimination. So I looked at 33 countries, including the UK, and I looked at those reports from 2011 to 2022. The reason that I chose those timelines, it was 2011 was sort of the starting point of when those concluding observations were issued by the committee, and 2022 was when I was doing the research. So up to 2022, there were 4 countries, including the UK, who practiced disability-selective abortion. And I also compared those countries' legislative framework against the CRPD committee standards for termination of fetuses with disabilities. Although the committee does not expressly set a sort of scale for termination or the severity scale for termination, they, in various reports and various concluding observations, they expressly say that selective abortion is only permissible if the prospective fetus is diagnosed with severe fetal impairments. So as you can probably see, there's an emphasis on the fetal element of the impairment. So it cannot just be any impairment, like Down syndrome is not fatal, but the UK abortion law still allows for a very broad scale of termination, whereas the standard by the committee, although it's not expressly mentioned, it is referring to as severe fetal impairment, and it's only allowing termination on that basis. So it is a narrower scope for termination as compared to what we see in the UK, particularly because of the word fatal, which has a higher severity threshold for termination rather than merely just focusing on any disability of the fetus, because the current standard by the UK, it's a very medicalized, as we already saw in the earlier part of the presentation. It is very medicalized, and the focus is on the disabled fetus being severely handicapped, which is a very medicalized term of describing disability and impairment, but also not having any severity scale. And I also looked at Northern Ireland as a case study, which had a reform in 2020 to make the laws closer to the CRPD standard for selective abortion. And the 2020 legislation in Northern Ireland only allows for termination of fetuses with disabilities without time limit if the condition of the fetus is fatal, i.e. if there's a substantial risk of death of the fetus occurring either before or during or shortly after birth. So it is not permitted, unlike the UK, to abort fetuses with disabilities up to due date. So there's a time gestation. If the severity is not meeting the fatal standard, there's a time gestation of 24 weeks, but to have a cutoff point, which is again very different to the current law in the UK, but the termination without time gestation can only happen if the impairment is fatal. Other than that, there is an equal gestational period between non-disabled fetuses and disabled fetuses, which is a closer legislative framework to the international standards under the CRPD. And I've looked at various ways of reforming the UK current law. One of the ways in which I suggested in my research was to introduce a common 24 weeks time gestation between disabled and non-disabled fetuses. And the idea behind that is to create a balance between this conflicting idea of women's choices to terminate and bodily autonomy on one hand, and disabled people's rights and non-discrimination on the other hand. So one way of making those balance is to have an equal time gestation, because I'm not arguing for a total ban of disability-selective abortion, but what makes the current law discriminatory is those differential treatment and not necessarily the termination itself. So another way of sort of reforming the UK law was to introduce a higher severity threshold for termination, and only allowing termination without time gestation only if the fetal abnormality is fatal. So that way, the UK law will be closer to the UN international standards under the CRPD. And also there's a balance between women's rights and non-discrimination elements of termination. And I'm sorry if I've gone very fast on that. But if there's any questions, I am happy to take it, and thank you for listening.
Okay.